Good morning, everybody. I'm Felicity Stedman, Director in Conflict Dynamics and a mediator and trainer over the last 30 years, both in the UK and in South Africa. Welcome to our webinar this morning. We've got people joining one at a time. We've got 60 people so far. We are expecting quite a few other people, more people. But I think we want to get going because our time is short and we have 3 speakers who I'd like to get to before too long. So just to begin with, a couple of comments about the purpose of our webinar and what to expect. In reflecting on the topic, I realized that in fact COVID-19 and Rule 41A have in a sense created a perfect storm to get commercial mediation going in South Africa. On the one hand, there are potentially many disputes that are emerging or going to emerge out of our lockdown social distancing situation. The courts are not functioning effectively at the moment or normally at the moment. And no doubt lawyers are scrambling to address their clients' needs to resolve these disputes. This is the fifth of our free webinar series supporting our clients during the COVID-19 lockdown. And if you would like to see the recordings of our previous webinars, in particular the one last week with John Brand on more general questions in relation to Rule 41A, please have a look at our website. Our panelists today, our 3 panelists are all Conflict Dynamics accredited mediators who are members of our panel of mediators, CD Direct, the details of which are also on our website. They are also all lawyers. So I'm putting the mediation side of them first and putting the lawyer side of them second, although that is the role that we are going to focus on in our session today. Chris Todd is Head of Dispute Resolution at Bowman's. PJ Veldhuizen is Head of Corporate Client Division at Gillen Veldhuizen Incorporated Law Firm. And Hendrik Kotze is previously of the Cape Bar, currently working in a number of different capacities, particularly in the legal technology development area and working very widely in the dispute resolution field. Craig Hulscher, the person behind the icon, is our administrative manager and the producer of the webinar. So in our session today, the process plan is that I'm going to make a couple of words about where we are in relation to Rule 41A and lawyers. And then each of the panelists will share a perspective on Rule 41A for about 8 minutes. Please submit your questions in the Q&A section at the bottom of the screen, and we'll address them after they've each given their input. We're recording the session, as you can probably see in the top left-hand corner of the screen, and we'll distribute an edited version along with the PowerPoint slides in the next few days. All of this is available on our website. I see that there's a point in chat as well as the other area where you can make points. And right, the question is about our past webinars. Yes, if you look on our website under resources, you'll see the recordings and also the PowerPoint presentations. By way, very briefly, of a background, Rule 41A came into operation on the 9th of March in relation to High Court litigation. It requires parties to consider mediation before proceeding with litigation in the High Court. And we know that there are rules that apply also in the magistrates court scenario where mediation has been available for some time, but hasn't actually, we don't think, gained much traction. All of this is good news for lawyers. So we want to really emphasize that Rule 41A is an opportunity for lawyers, and it is an opportunity for them to engage in mediation in new ways. It is an opportunity for them to represent their clients in a new forum as mediation advocates. They will be in the mediation and they can work very closely with their clients in preparing for the mediation and then, as I say, actively in the mediation, and then support them in the implementation of the settlement agreement. We always regarded lawyers as key role players in mediation. And when we train mediators, and we have trained literally hundreds of commercial mediators in South Africa, to international standards, we encourage our mediators to involve lawyers in the process right from the beginning. And they are involved because they bring a very important legal perspective, particularly from the point of view of risks. But that doesn't necessarily, that's not necessarily the only focus, because the focus of a mediation, commercial mediation, really should be about the commercial interests that the client brings to the dispute. And the lawyer, of course, is going to advise the parties also on how to deal with those commercial interests and have them met by a good settlement agreement. So they certainly have a key role. So our three speakers are going to consider Rule 41A from three different vantage points. Chris is going to start off by having a look at some broad questions in relation to Rule 41A and the implications for lawyers. PJ will have a look at preparation and the role that lawyers can play in preparation. And Hendrik will have a look at technology in particular and some of the practical implications of Rule 41A for lawyers. So Chris, I'm going to turn over to you to begin with. Craig, can we have the first slide?
Thank you very much, Felicity. Much appreciated, and thank you for the opportunity to participate in a conversation like this. Thank you also for the 8 minutes, and also for suggesting a new short form. I heard it, I think it was a slip of the tongue, but to commercial mediation comedian. It sounded like those two things were becoming elided. But that's a role I hadn't thought of myself in as a lawyer involved in commercial mediation. Let me dive into the 8 minutes. The first question I thought I should just discuss and put out there is really what changes different, or what is going to be different for lawyers, litigators in the world after the introduction of this rule, and why is it likely to change anything that we do in our practice? And that's the reason why I've suggested the first point is that any litigators, and certainly anybody who's been thinking carefully about their practice over the last few years, will already know very well about the availability of mediation, including in commercial matters, any form of litigation in the High Court, and also will know of its potential benefits for clients involved in litigation. I've emphasized reference to the client because I heard you say this is good news for lawyers, but to me, the obvious point is that ultimately any assessment of whether or not to mediate, the timing of mediation, and how we go about it must be conducted by reference to the interests that a client has in relation to the resolution of their matter. And although that might sound like stating the obvious, I always restate it just because too often the topic discussed by reference to, oh, but what about us as the lawyers, and are we still going to get our fees? The fundamental point is we know that mediation is available, and we already know that we should be assessing its potential benefits for our clients. So what changes with Rule 41A? Can I have the next slide, please, Craig, or the next points? The main point here is, even though we know as litigators about the availability of mediation, it doesn't make it easy to get one going in the context of a commercial dispute. And there are many reasons for that, which are pragmatic and not about lawyers thinking about their fees. The first one actually is that some clients are quite prickly about suggestions from their lawyers, particularly in the early stages of a matter, to say, okay, I hear you've got this big problem. Now let's talk about how we can try and settle it. And let's talk about mediation. I know you want to sue the other party, or you're upset that you're being sued. Let's see if we can try and settle. Sometimes that isn't an easy conversation to initiate with a client. Also, it's not always very easy to decide exactly when to mediate. Mediators, we believe so powerfully in the value of the process that we sometimes make the assumption that any time, the sooner the better. And there are some disputes or litigation matters which actually do evolve in a way that requires some quite careful thinking about the optimal point at which to initiate settlement or to trigger a mediation process. And then, of course, the third point that I make there is that approaching your opponents to mediate is also not as easy as it may sound. I've had plenty of situations where a client has legitimately said, if we propose mediation now, aren't they going to see that as a sign of weakness? And won't they think that we're not confident about our case? How do we tell them both that we're confident about our case, but also that we're willing to enter a mediation? And so those are all reasons why lawyers actually might find it a little difficult to get over the hump of starting to talk about the mediation process and initiating it. Could I have the next point then, Craig? I guess the next question is, well, what does the rule actually change? And are parties, lawyers or their clients, not just going to say, you know what, sure, there's a rule now, but we'll just tick a box. We'll just say, we are interested in mediation, or we're willing to mediate, or we're not, and we'll just carry on with the litigation, because the rule doesn't actually carry any sanction or immediate obligation to do one or the other. And I think that is always a risk when you introduce a requirement like this, but I think that the rule itself has got a number of, let's call it checks and balances. It's got a number of things in the construction of the rule which actually make it a serious rule that is going to require parties to give proper consideration to mediation before they either initiate litigation or oppose it. So let me turn and look to what those things are in the rule that I'm referring to. If I could have the next slide then, please, Craig. And the next block of text, please. So paying lip service to the rule, and I said ethics and professional conduct aside, I hope that lawyers won't think, oh, I'm required to give an indication or consult with a client about whether or not to mediate, but I'm in a hurry, so let's just tick a box and say yes or no. That would seem to me to be paying a little bit of inadequate attention to one's professional responsibilities and one's ethical duties to the client. But that aside, what about the rule is going to make this difficult? And I've listed a number of points there. The first one is the rule. If you've read it, you will know. It says when you sue out, when you initiate litigation, either by way of summons or application, you've got to fill in, and it's a Form 27, what you can make your own form. It basically indicates upfront two things. The first is whether you agree or to refer the matter to mediation or oppose mediation. And the simple thing there is that you can say, well, I can say either. It doesn't really matter. But the rule, you will know, and you should know, says that when a court comes at the end to assessing allocation of costs, it may take into account what a party said right at the beginning about whether they agree to mediation or oppose it. And there straight away is some subtle psychological pressure, because you can imagine if a plaintiff or applicant says, I'm willing to agree to mediation at the time that they put out their case, it's quite difficult for a respondent to say, no, not interested, because a respondent then knows that perhaps even if I successfully defend this case, I may not recover costs. And in some ways, I'm under some pressure to think, well, if the plaintiff is willing to mediate, maybe I should be as well. So, and similarly, a plaintiff who's going to say, no, I oppose mediation, will have to be thinking, but what if the respondent then says, yes, I am willing to mediate? I'm then going to look as though I am an obstacle to potential settlement, and that could cause adverse consequences for costs later. So just in the very statement up front of your stance, it seems to me is going to have some measure of effect in causing parties to take mediation very seriously. The second point actually is perhaps more far-reaching, and it says you've actually got to not just state your stance, but explain it. It does say clearly and concisely. It doesn't require a long document. I would imagine a clear and concise statement should normally be in a sentence or two, perhaps a short paragraph. But you are required to explain reasons. Then there's a curiosity in the language, which I don't want to get too tied up with, but essentially it says you must explain your reasons for believing that the dispute is capable of mediation or is not capable of mediation. That's a little curious because as certainly those who've thought deeply about mediation will know, almost any dispute. I don't think anybody would go so far as to say every dispute is capable of mediation. And one can think of some, for example, where a party, a public interest litigator, wants to set aside an act of parliament or a particular provision of an act of parliament. Those kinds of disputes are probably not mediatable in their totality because there's nobody other than the parliamentary body itself that can agree to set aside a law. But that type of case aside, most matters are capable of mediation. And so strictly, it looks as though the rule is asking you to say, do you accept that this dispute is capable of mediation? It's a little curious because the Form 27 then accepts that you must merely state, or it seems to suggest that you merely state whether you agree or disagree to mediate. And I think probably your clear and concise reasons require you to explain why you are or are not in favor of mediation of this dispute and whether you are or not agreeing to mediate this dispute, because it could have been an eminently mediatable dispute which you have already made exhaustive attempts to mediate, for example, and that might be your clear and concise reason why you don't want to mediate in this case or agree to mediate when you issue summons. Or similarly, you may have gained an impression on reasonable grounds that the other party are just stringing you along and decide you're not going to mediate for that reason at that point. So that's how the rule is constructed with those two main points. Are you or aren't you agreeing to mediate, and what are your clear and concise reasons for it? Craig, if you could pull up the next slide, please. I've mentioned there's no early enforcement mechanism in the rule. That's obvious. You don't want interlocutory fights up front about whether you should or shouldn't be mediating that have some sort of justiciable or enforceable element. And so that does mean that any reasons you've put up and whether you have or haven't agreed to mediation will only be taken into account at the end of the matter in relation to costs. And that might be seen to be something which is far away, but it does mean, for the reasons I mentioned earlier, you'll have to think quite carefully up front about what messages you're sending and how you're going to explain that if called upon to at a later stage. The next point then, please, Craig. So it seems to me that the rule, when you read it properly, can't be glossed over. I don't think parties are going to be able to. I think they will run into trouble quite early putting aside an attorney's professional duties if they just gloss over it and say, oh, in a very superficial way, we are or aren't in favor. And I think that means that serious consideration will have to be given to mediation right at the beginning of litigation. I make the point there, and this is important, merely agreeing up front in a notice that this matter is suitable for mediation or agreeing that you're amenable to mediation doesn't itself initiate a mediation process. That will still require the conclusion of a mediation agreement. The rule, in fact, says specifically that parties must agree to, must actually conclude a written mediation agreement. So there is a little bit of a sort of a grey zone in which parties could become a little bit into the sort of no man's land of agreeing to mediate but not being able to conclude an agreement, although that shouldn't really happen very often because mediation terms are not difficult to agree ordinarily, and there are lots of good standard form agreements around. And the next slide, if I can, Craig. So then just a few comments using the last of my 8 minutes on some practical consequences. The first one is there's no client should object, and in fact, no client can reasonably object to having this topic of mediation raised early. Now, there can be no prickliness. In fact, the client has to give good instructions on the appropriate stance for the lawyers and for the client to take up front. And secondly, suggesting mediation to the other side is not a weakness because you've got to state up front what your stance is. So it seems to me that the existence of the rule cuts through some of that sort of uneasiness that might exist either in a lawyer's conversation with the client or with the other side about whether or not this dispute is suitable for mediation. Thanks. The next point, Craig. So, okay, this point, I think it follows automatically. It means that lawyers with their clients have to consider timing and settlement potential of mediation early in a dispute process. The next one, please, Craig. This is actually a point that Hendrik made when we were having a conversation a couple of days ago, and it's a very important one to bear in mind. And I think I mentioned when we had the conversation, I've experienced not having two teams to my cost in some matters, but in particularly complex matters, the requirement of considering mediation early. One of the barriers to early mediation is a focus on an effective litigation strategy. And at a time when a legal team is very focused on its litigation strategy, it is sometimes very difficult and slightly schizophrenic to be carefully planning a mediation or a settlement strategy in parallel. And so it does raise the possible need, and certainly in matters that are where there's enough at stake and where there is certainly justification for incurring costs, to consider having two different teams focusing on different aspects of the matter. Next slide, please, Craig. Or the next topic. So the rule itself does recognize that disputes are not globular or always single. So there may be some points in a dispute that are more suitable to mediation or early settlement than others. And the rule still, in effect, encourages that by saying if you can streamline the litigation or cut out some of the issues, that's really important, and so you should do it. The next points, please, Craig. I think we're on the last two. I make the point that a practical consequence is, even when parties don't agree to mediate or haven't both agreed up front, what they say as their reasons might itself indicate, for example, a plaintiff says, I'm not willing to mediate because I don't think there's any defense, and I haven't even heard an explanation for why the defendant hasn't complied with my demand, and therefore I'm not willing to go into mediation at this point. That would sow the seed for a defendant later saying, well, actually, once I've put up my explanation, perhaps then this dispute will be suitable for mediation. So there may be things said in the explanation up front that trigger further thinking about mediation at a later stage. And then my last point, actually having it in the rules or anywhere else, having a good understanding of the process, having parties willing to mediate or to submit to mediation is never going to be, it doesn't make disputes automatically become resolved. There's no magic wand in mediation. And I just think it's worth, particularly when one is talking to mediators. Sometimes mediators, we're inclined to think the problem is institutional. The problem is the courts aren't encouraging it. The problem is parties aren't participating properly. And I suppose I throw down the challenge there to say, yes, you need rational and well-prepared parties, but you also need good mediators. So parties and lawyers representing parties, their experience of mediation as an effective process, in my view, is going to be possibly the most material factor that is going to result in mediation becoming a normal part of our dispute resolution cycle in commercial matters, and perhaps will play an even bigger role than possibility of cost sanctions later if you make the wrong call early. So I've stepped over my 8 minutes. Apologies, Felicity, but
okay.
To have a conversation later on any of those points.
Okay, thanks, Chris. And there has been a question from Andre Oosthuizen, which, Chris, maybe you can think about and we'll come to later, about whether the question around costs and the dealing with that in relation to a refusal to mediate or even what happened in the mediation doesn't in any way harm settlement privilege and confidentiality aspects of the mediation process. So we'll come to that. And Chris, thank you for ending with a strong point about the use of good, accredited, experienced mediators. PJ is now going to take over, and he's taking over from the point of assuming parties have agreed to attempt to resolve their dispute in mediation. What do they need to do next? And PJ, there have been a couple of questions about the difference between mediation and arbitration and litigation, and you make that point in your presentation, so please focus on that. You might also just answer the question which we've had from Ishra Odasing about whether Rule 41A can be invoked in matters that are already have already commenced with litigation. So, you know, where do we fit? I mean, there is Rule 37A, which gives opportunities, gave opportunities all the way along for people to mediate. But let's hear from you, PJ.
Thank you very much, Craig. If you can just put up that first slide, please. Thanks. Okay, so I made the point that if the parties have now agreed to attempt mediation, the difficulty is very often the clients themselves don't understand the difference between mediation, arbitration, adjudication, or litigation. And it's important right up front to explain what mediation is not. And by this I mean, you need to explain to your clients that the mediator is not going to come to a decision at the end of the day. The process needs to be explained clearly to the client in that the mediator's role is a facilitative role in order to be able to get the parties to a settlement agreement that they will all then implement. If I can have the next point, Craig. So what I like to do in these situations is to prepare a step-by-step guide for the clients to read at home. So firstly, what I like to do is I like to send them a document setting out what mediation is, which gives the differences, as I said before, between arbitration, litigation, adjudication, and mediation. And then also I like to give them a step-by-step guide as to how the actual mediation process will work, how joint meetings are held, how breakout rooms are held, and so the parties don't come to the mediation on the day and feel intimidated or overwhelmed by this new process. Craig, the next one, please. Okay, if you don't have a document like the ones I've just described, ask your mediation service provider, like Conflict Dynamics, or if you're at the company's tribunal, perhaps the company's tribunal, or if you don't have this, the mediator themselves will often share a breakdown of exactly what the clients can expect on the day. Now the next point, Craig. Thanks. Reiterate to your client in preparation that the mediation is in absolute confidential terms. Nothing can be used later in litigation if the mediation fails. It's a safe space where they can brainstorm any option. And that's the beauty of mediation, where the binary system of litigation, where there's a win-lose outcome, anything is on the table here. Litigation remains one arrow in the quiver, and the client should be encouraged to put anything on the table. Next point, Craig. Okay. We've said already that anything said during the mediation is inadmissible in any future litigation. Next point, Craig. Okay. Remind yourself of this too, that while litigation, it's very difficult. I've always found, and witnessing lawyers being trained and judges being trained as mediators, this is not litigation light. Litigation is always an option, but it shouldn't be the only focus in the mediation. And what I also, in my experience, I've seen, when you suggest to your opposition attorney or to other clients that mediation should be examined, very often clients will say, I will only go to mediation if they concede this point or that point, or if they will pay the costs, or it's something like that. And encourage your clients not to make the mediation conditional. They should enter into the mediation with a view to settlement, not trying to get points scored early. The next point, Craig. Remind clients to trust the process. They must keep their eye on the prize, and the prize in this case is always to avoid the debilitating costs of litigation and the uncertain and the vagaries of litigation. They should be aiming at getting to a settlement and getting on with their lives. Next point, Craig. Okay. In the preparation, explain to your clients what the binary situation that comes out of litigation means versus the benefits, the speed, the options, the high rate of settlement, and then also the rate of compliance with settlement agreements that comes out of mediation, particularly as a result that the parties have come to the settlement themselves. It hasn't been foisted upon them by a judge or an arbitrator. Next point, Craig. Okay. Lawyers have a big part to play in this process. I know I've heard in the corridors that many lawyers are fearful that this is going to take work away from them. This is not the case. Lawyers have a role to play in the drafting the opening statements, drafting the mediation agreements, in assisting their clients with the litigation on the day of the litigation, explaining what alternatives to coming to a settlement can be. They bring a mind to bear, which I think is invaluable in the mediation process. And I encourage, certainly in my mediations, that the lawyers are present, because I think that they're a very useful part of the team. Next point, Craig. I've said that already. Next point, Craig. Okay, I've said that as well, that the lawyers themselves are generally very, if you just go back, I think the lawyers themselves are well placed generally a litigator who's been involved in litigation for some time will be able to assist their client and the mediator, in fact, in what the likely outcomes and what their experience has been in matters that don't settle. And I think that that's the end of my 8 minutes. I hope I've come in within time.
Sorry, PJ, I'm going to ask you to answer one question, as you have a couple of minutes to spare, and that is the question about whether parties can invoke a Rule 41A in matters that have already commenced well prior to March this year and the implementation of 41A.
So my reading of the rule, and I thank Ishara for that question. My reading of the rule is that I don't think that you can force people to do that. I think that as I read the rule, it's for litigation which is anticipated or beginning after 9 March. That doesn't, of course, stop anybody at any stage of the litigation for suggesting it, and I think that the courts will look fondly, or should I say, I don't think the courts will look fondly on you if you raised the idea of mediation and the other party unreasonably suggested that mediation wasn't appropriate simply because the rule hadn't come into effect at the time that your litigation began. I think it's always appropriate to raise it.
Yeah. Okay. Just in relation to that, settlement agreements, sort of in relation to that, settlement agreements. Now, let's say you are mediating outside of the courts and you reach an agreement. And this was a question from Whitney Malcons, which actually arose prior to the webinar. So you reach a settlement agreement. How can you make this an order of court if you want to do that, whether it's at the level of magistrates court or high court? Just, can you give us some advice on that?
I'm not sure that if the litigation hasn't begun that you're entitled to make an order of court. I think that the litigation has to have begun before any settlement agreement can be made an order of court.
Okay, and then making settlement agreements in terms of mediation, in terms of 41A, would you make that then an order of court, and does the rule give you direction on that?
Look, I think at once, if you're operating in terms of Rule 41A, I think you can definitely have that made an order of court. But it would depend on the parties whether they in fact required it. Not every case requires you to go and have your settlement agreement made an order of court. It just simply depends on the circumstances.
Yeah. And I think our experience as mediators has been, in fact, that mediated agreements the compliance with mediation agreements is far greater in fact than decisions of arbitrators and of courts, because people have agreed this is what they're going to do. They've worked hard at reaching an agreement that they believe will work.
Absolutely, that's my experience as well.
Yeah. Okay, can you just comment very briefly on the mediators, because you've talked a bit about working with the mediator, and you have in fact very recently mediated online with one of our mediators. Now, what do you look for in a mediator? Chris has given us some pointers on what you look for in a mediator, but what would you look for in a mediator, and where would you find your mediator?
Okay, so here's my punt for conflict dynamics. I go to your website generally. But more than that, I look for somebody who I can have worked with in the past. And I look for experience. I look for somebody who brings perhaps not an expert view, but a view. If it was an engineering matter, for example, I would look for an engineer as my mediator. I like the fact that many mediators have legal degrees, because it again talks to the one option is always to revert back to litigation, and they bring an honesty to bear on that process. But I think, in short, it's experience I'm looking for, and credibility. Okay,
great. Okay, I'm going to turn now to Hendrik Kotzer. And Hendrik is going to talk us through how lawyers might have to adapt their practices for mediation, from what to expect in terms of Rule 41A, but also the use of technology, which is an area he has particular experience of. Hendrik.
Thank you, Felicity, and good morning to everyone. Craig, if you can put the slides up, thank you. Okay, so just from some of the questions that's come through, I do get a sense that one has to be realistic and understand that many practitioners out there don't really have a solid experience of what mediation looks like, and in that sense, the whole experience may well be new for them, and that's something that they would have to adapt to. I think in the 8 minutes that I do have, I'm probably going to spend a little bit more time in just talking about how possibly mediation practice itself might be influenced and change as a result of Rule 41A. And to some extent, we're speculating a little bit about what is going to happen, but I think it's worthwhile doing that. In the first place, I think it's fair to say that we're probably going to see higher volumes of mediation processes coming through, which means that practitioners out there will have to get used to that mediation, and participating in mediation is now an important part of their legal practice, and something that they have to structure into how they function in their practices. I also suspect that our traditional long form of mediation, where you book a day and you set aside the whole day to do a mediation, although there are many cases where that absolutely is the ideal way of doing it, Rule 41A may well result in parties saying, well, we'll give it a stab, but we feel it's maybe too much to set aside a whole day. We'll maybe try half a day, set aside 4 or 5 hours, and see if the process gets us anywhere. So that's possibly another implication that we may see many more mediations, but many of them may be slightly shorter in duration than what we had been used to in the past. I think the other important thing that we need to understand also, and just in the context of what I'm going to be saying further in my discussion, is we need to understand that Rule 41A mediations are happening outside of the courts. These processes are not being managed by the courts. The courts Rule 41A is simply asking the parties whether they have mediated, whether they're willing to mediate, and encouraging them to do so through private engagement with mediators. So these processes are not managed or administered in any way by the courts, and especially if we start to see higher volumes of mediation processes coming through, that is potentially something that has both opportunity and challenge. Craig, if we could have the next slide. Okay, so possible new approaches to mediation. I think the first one that I mentioned there, being online mediation, is already a reality. COVID-19 certainly has forced us to go that route. I think had you asked mediators a couple of months ago whether online mediation is something that they think is worthwhile doing, and whether they're steering their practices towards that, quite a few may well have been skeptical about it. But the reality is that with COVID, many of us have now been going online, and we have been mediating, and we've been mediating very successfully online. For those that have experienced it, invariably the feedback that I've heard is that people say the online mediation experience works very effectively. It does lose a little bit of the personal rapport building component that you would have of an in-person meeting, but that does not mean to say that you can't effectively build rapport and manage a process to get to resolution. I think most of the people on this panel have had experience of that, and I think we can all testify to it that it actually works very effectively. That probably brings about a fair degree of logistical savings, just being able to schedule a meeting online with yourself and your clients, even being in different locations, and getting onto the mediation meeting and then actually doing the process. It makes it easier to fit in, and I think it's something that's here to stay. Probably not for all cases, but it's something that certainly will be used to a much greater degree. we've all got, we've all been using the Zoom environment for these mediations. It takes a little bit of practice to just figure out how to do that in that environment, but it actually is quite supportive of all the different functions that you would need as a mediator. I think a second thing that I see Rule 41A bringing about is maybe an increase in what I've called asynchronous mediation processes. What I mean by that is a mediation process where all the parties are not necessarily together for a specified period of time with the mediator shuttling between them, but rather a process where the mediator engages with one of the parties, does a little bit of work in terms of what they need to get closer to settlement, and then maybe as and when the other party is available on the same day or the next day or later in the week, engaging with the other party and in that way moving the process forward. And sometimes this needn't even be through conversation, but it can also be through chat functionality. Past experience that I've had in facilitating and in mediating in compensation cases, and specifically road accident fund disputes, this has been a very effective and a very useful way of actually mediating those processes. Very often the challenge there is not so much about getting the parties to understand each other's needs and interests, but actually it's a question of getting the right set of information on the table so that the one party can make an informed offer and the other party can understand what a realistic offer is to accept. And through facilitating that exchange of information and getting the parties to a point where they can reasonably make and consider offers, that asynchronous mediation process actually works very effectively. So again, I think that's something that we need to consider as mediators, and we need to start thinking about. Craig, next slide, please. Okay, so my last point is really about considering the adoption of information technology platforms to support some of the mediation processes. If the reality is that mediation is going to become a much bigger part of practice, then well, let's use the technology that's available out there to make that practice easier and to support all of our already exist that are out there to actually start doing many of these things, and just to highlight some of the things which we can consider as being supportive of our mediation practice: electronic filing of mediation requests, developing online case files where all the documents that are relevant to the mediation case don't get sent around through emails, etc., but actually are just uploaded into an environment, an online case where they're available to whoever needs to see them, and creating communication and negotiation tools in that online space, specifically around supporting the asynchronous mediation process. The online communication tools are often very effective, especially if it's situated in the environment where the rest of the online case is also available. And then proactive mediation case management. It often is very useful if the management of the mediation process is not just left to the parties or to the mediator, but actually you have technology that assists in driving that process and informing the parties if more documents have been uploaded, if more messages are there in terms of an asynchronous mediation process. So in short, I think that this offers great opportunity for exploring the IT support, which maybe is still lacking in the litigation environment. Thank you.
Thank you, Hendrik. I want to just underscore Hendrik's last point about case management, whether it's on a secure IT platform or it's done by a provider like Conflict Dynamics. I can't emphasize enough how important case management is in the very sensitive situation of mediation. So for parties and their representatives to go directly to a mediator and say, will you come and mediate our dispute? You can just imagine the questions and concerns that will immediately spring to mind in the mind of the other party. The suspicions, who is this person? Are they qualified? Are they now coming to negotiate on behalf of the party who has suggested them? So right from the beginning, we'd encourage lawyers, representatives and parties to think carefully about who are they going to appoint as a mediator. We've heard how important it is to have someone who knows what they're doing, who is credible, robust, confident, but also that that mediator is from the beginning acceptable to both parties and can coach and work and work with and influence both parties, bringing them onto the same page, the page of agreement. Thank you very much, Hendrik. I want to just go back to Chris, if I can, in our last 15 minutes with a first question, and then we'll open it for other questions. There have been a couple of questions relating to the potential for a cost sanction and also confidentiality. So, Chris, you started the point around cost sanctions. When the inquiry is made, or the discussion is had later on at the cost sanctions stage, to what extent do you think the confidentiality and privilege of the mediation situation and of settlement discussions will be challenged? And also, how can we work with parties and judges to understand how important it is that these principles apply in order for mediation to work effectively? And sorry, then just related, no, answer that one. I'll come back to the next question.
Look, I'm not worried about that the way Rule 41A formulates this point. And in fact, all the rule itself says is that what can be taken into account is your stance articulated up front. As to whether you agree or support or don't support mediation. But of course, that stance, as I've said, includes a short explanation of your stance. Now, there's two reasons why I'm not worried. One is the party's in control of what they're going to say there, and I don't have to say things that are privileged or confidential in their reasoning, in their short and concise reasons that they wouldn't want somebody to take into account later. But two other more important things. First, the subject matter of discussions in a mediation. It's not suggested that that would ever be put in front of a judge. And lastly, in fact, the way the rule envisages it, it's not much different from the existing rule, which permits settlement offers made with prejudice to be put in front of a court at a later stage. Because actually this rule envisages that there's a judgment on the merits first. And then it doesn't actually spell it out exactly the order it happens. But once a judgment has been made on the merits, and a party would presumably have to signal to the judge that they will want to argue separately on costs, or whether that will become normal practice, I don't know. But here, what is envisaged is a judgment on the merits, and then afterwards, the judge says, right, is there anything I need to know of relevance to costs? And then to whatever you can make of it, what was said right at the beginning about a willingness or not to participate in mediation may or may not influence the judge in deciding on the allocation of costs. To me, I think that's I think that poses a risk to the confidentiality and without prejudice or privileged nature of mediation. It does require intelligent judicial decision-making later. I've heard the complaint that says the mere fact of using a cost sanction somehow impinges on a party's freedom of access to the courts. But I think I've never seen any jurisdictions which use this as a relevant consideration, and there are others. The UK is the one that we follow most closely. I've never seen it used in a way that could reasonably be said to infringe on parties' rights in the litigation.
Yeah. Chris, just to extend the question around confidentiality, not in relation to cost sanctions, because we understand what you've just said, but I think people, there are a couple of questions. Zenobia Dutoy, for example, has asked a question about does confidentiality of mediation proceedings extend to financial information and documents exchanged during the mediation? So just tell us a bit about confidentiality of the mediation and what parties and their representatives can rely on later if the matter doesn't settle, for example.
Yeah, so Rule 41A, as I said earlier, requires a written mediation agreement. It doesn't envisage you just find yourself in a mediation. But I think the inherent in mediation is at the very least, I don't think a mediator would normally accept a brief without at least this confirmed in writing. But even if it wasn't, it would be confirmed up front. Whatever we say here can't be used in litigation, and that includes documents exchanged in the mediation. But that point is always regulated explicitly in a mediation agreement. It does, so what an agreement would say though, any document, even what Zenobia you're referring to, facts like financial information, if it's first disclosed in mediation, in the context of mediation, that can't be used by the other party in litigation. But of course I do make the point that once you know something exists, you can be expected, if it's going to be relevant to subsequent litigation, it can be called on in discovery or something like that. So you can't, a party shouldn't be surprised if it actually discloses facts in a mediation that then doesn't settle, that the other party is now aware of the existence of those facts. So there are some ways in which what happens in mediation becomes known to and could become relevant in later litigation. But I don't think that is anything that ought to trouble parties. It requires perhaps careful thought about an approach to mediation, but inherent in litigation and the discovery process is actually that every document that is relevant and material to the outcome of the case actually has to be put into the other party's possession at some point. So, there's a limited amount of gray area in between. But the principle is that documents disclosed in mediation for that purpose can't be used outside of the mediation.
Yeah. Okay. PJ and Hendrik, do you want to comment on that last point at all? No, you're okay. All right. There are a couple of other questions that I'd like to just deal with. Maybe I'll just go to the questions. Craig, if you could just turn to the last slide, let me talk to that, and then I'll go back to our panelists with for a few last comments. So how might conflict dynamics assist? So there've been a couple of questions that have come in on the Q&A and the chat about where do you find the mediators and what are you looking for? And then also how much do they cost, etc. So Afzal will address your question on how mediators will quote their cost their time. So conflict dynamics has trained many mediators over the last 13 years. We've trained them to local and international standards, and what we mean by that is that they are all also accredited by DISAC. Well, those people who join our panel, let's say, the CD Direct panel of mediators, and to join the panel, you have to demonstrate that you have experience. So on our website, you'll see there is a page where everyone who we have accredited is listed, but there is also a page called CD Direct, which is the mediators who we have who have applied to us to join the panel, and they have confirmed their experience. They then become DISAC accredited, so they meet DISAC standards. DISAC is a Dispute Settlement Accreditation Council in South Africa, the overarching standard setting body. And we also are closely linked with the International Mediation Institute and have been accredited by them. Our course has been accredited by them, so you can become accredited or recognized by them, as well as CEDA, the Centre for Effective Dispute Resolution in the UK. So you can find a panel of mediators, which at the moment is about 50, who we can confirm have experience as mediators. They are covered by professional indemnity insurance, the conflict dynamics professional indemnity insurance, which is very important. Of course, lawyers and many other professionals will already have their own insurance, and we would encourage you, if you are a mediator, to extend your insurance to cover mediation. It doesn't happen often that there's a complaint, but should there be a complaint, for example, that you divulged something in a mediation that was confidential and you shouldn't have, or you pushed the parties too hard to settlement, and one party is unhappy with that, well, then you might have to employ one of our lawyers to defend you in a claim against you as a mediator. So the mediators are listed there. You can search our website by location. If you want an in-person mediation face-to-face, then you might want someone who is closer to you geographically. You can search our website by people's experience. So if you want someone who is familiar with the rental sector or property and landlord and tenant sector, you can search landlord and tenant. If you want someone who is not only experienced landlord and tenant, but also with contracts and breach of contract of all kinds, and we know there are going to be a lot of breach of contract cases involving landlords and tenants, then you can find the mediators who have that sort of background and experience. You can then click further and you can find their bio, and you can find out, are they a lawyer or aren't they a lawyer? What is their experience? So those people who do prefer to have a lawyer, you can find a lawyer, but there are many non-lawyer mediators who are experienced and very successful. So in terms of how conflict dynamics works, you approach us, we suggest a couple of names, or you might find the names on our website and ask about those people. And then between the parties, they agree on who their mediator is. The mediators will indicate their costs, their charges by hour or by day, depending on what the clients want. So we're entirely flexible. We want to really match the dispute with the appropriate mediator. I'll just stop there for a moment and go back to our panelists and ask if you want to add anything on those points and your experience of mediation, or indeed anything further before I make our last few conflict dynamics points. Let me go backwards and start, Hendrik, with you.
Yeah. Felicity, maybe just to mention that Rule 41 doesn't know which people are qualified to mediate matters, and I think in some way the drafters of the rule tried to dodge a bullet there by not being specific about it, but it may have also created an additional problem where unqualified and untrained people may actually try and mediate some of these cases, and I think just from people who have experience of mediation and who understand what it takes to actually mediate a matter, that could probably be the worst thing that people could do. So wherever you are in practice and you are faced with selecting a mediator, please make sure that the people that you do select are trained and qualified. Obviously, Conflict Dynamics has a panel, but there are a number of other panels out there as well, and there is South Africa has a voluntary system of qualification certification in South Africa through DISAC, disac.co.za, which sets out those standards, and so there are a number of trained, qualified people recognized as such in the industry, and please make sure that you use qualified mediators in these processes.
Thank you. PJ?
Thank you, Felicity. I just think another point to make is for lawyers to get training on mediation, even if they don't wish to actually practice as mediators, but to take the time to get the mediation training so they know what they can expect and they can navigate their way around the process. It's a bit like learning courtcraft. Learning how to take your clients through a mediation process is very, very useful, I think.
Yeah, yeah. And again, you'll find on our website courses, which we will be running online shortly for lawyers and other representatives in relation to Rule 41A and how to work with your clients. Chris?
Not a lot to say. I said mediation isn't a magic wand, or sometimes people talk about silver bullets, although I don't like that analogy as much. But the point for me is mediation provides, if properly executed by a well-trained mediator, provides an incredibly powerful opportunity either to settle even the most complex dispute, or to settle parts of it, or to narrow the issues in a way that makes litigation more manageable. So in my experience, in fact, has been more in mediations and doing the legal representation work in mediations than outside. And I can say that in cases where parties understand their case properly and are committed to finding the most effective solution for their clients, and where a mediation process is run properly by a mediator. Mediator is not just a warm body that kind of lurks around and says, can I help you settle your problem? They've got a very very important, a very structured process to facilitate that negotiation. But I found it incredibly successful in very difficult cases where executed properly. So I guess my emphasis is parties take the process properly and prepare properly for it, and seek out mediators who are going to be energetic and active proponents of mediation. And then I think it's about as close to a magic wand as we'll get. Thank
you, Chris. Thank you for those points. And just to end on a point about the acronym ADR, I think sometimes people refer to it as, or lawyers might think of it as alarming drop in revenue. Sometimes, or traditionally, it's been referred to as alternative dispute resolution. I think what we want to emphasize from the conflict dynamics point of view is that really it's about appropriate dispute resolution. And there is a place for litigation, there is a place for arbitration, and as Chris has said, executed well, mediation can be incredibly helpful to the lawyer in their quest to satisfy their client's need to have the case managed well, quickly, cost effectively. So Craig, if I can just have the last slide again to make the last 3 points, and then we will end. So on this last slide, the last 3 points, PJ has made the point: train your legal team to represent clients in mediation. Be trained yourself. Train your clients in negotiation skills for effective mediation, so that they know what to expect. It is, after all, as PJ said, a facilitated negotiation. And then train as a mediator. Actually, the best way to understand mediation is to immerse yourself in a mediation training course. Not everyone trains as a mediator to be a mediator, because there's a lot of work that comes with trying to get a mediation practice off the ground. It takes a long time. But training as a mediator gives you a very good insight into what mediation is all about. So thank you, Chris. Thank you, PJ. Thank you, Hendrik. And thank you to our, at one point in time, 91 participants for your fantastic engagement. We will put an edited version of this recording, of this webinar, on our website, and also put our PowerPoint slides up, and we'll let you know when that has been done. We have a webinar on Thursday about the RAF and mediation, and so please look on our website and join in if you are available. Thank you, everybody. Bye-bye.